There are actually 7 articles to the Constitution. Article 4, full faith and credit, also deals with interstate relations, extradition, things of that nature. Full faith and credit right now is under attack by the state of Massachusetts because of the Defense of Marriage Act of 1996, which was a law that essentially is based on a clause of Article 4 that says that Congress has the right to determine how states must give full faith and credit to the judgments, court orders, and laws of other states. It's going to be a very interesting case to watch. It's going to be more troublesome if the current administration, the Obama administration, is able to appoint someone to replace one of the more conservative members of the court, quite frankly, because I believe the conservative members of the court would probably find the Defense of Marriage Act is a lawful extension of the power granted in Article 4, but that's a battle that has yet to be fought. In Article 5, they discuss how you can amend the Constitution, and if we talk more about that in depth, we'll realize there are essentially 2 ways to amend the Constitution. One is by national convention, which has never been done for a variety of reasons. I think people are afraid they'd go back and mess with the rest of it. And the other is by having 2/3 of the Senate and 2/3 of the House propose it and then sending it to the states where it's ratified by 3/4 of the states. The 6th article is the Supremacy Clause. And that is the clause that says this Constitution is the law of the land, the supreme law of the land, and makes everything the federal government does higher than the states. And as we'll discuss in federalism, this has sometimes led to problems, but the concept of it was in order to create a united states, you had to say, in the event of a conflict between state laws and federal laws, the federal government is granted the power to be supreme. Finally, in the 7th article, it dealt with ratification. Ratification was simply requiring that the conventions of 9 states, 9 of the 13 states, ratify the Constitution in order for it to be carried out, in order for it to be a binding organization. It's interesting that even if you were one of the 4 states that did not ratify the Constitution, in theory, once 9 states had ratified it, you would then be considered to have been bound by it because you had representatives there when the document was drafted. Fortunately, it came to pass after the Bill of Rights, which we'll probably address in a different lesson, that all of the original 13 colonies or states, of course, as they became, ratified the Constitution, and so it never was a problem. We did have a question at one point surrounding ratification about what do you do if you get in and then decide you want out. That question began to really come to the forefront in the 1840s, culminating in the Civil War, began in 1861, and by 1865, in April, with the surrender of Lee's troops at Appomattox Courthouse, I think it was pretty well settled that the Union could not be dissolved. Secession was simply no longer an option. So that concludes our brief overview of the Constitution. We'll move into more of the specific areas and talk about some of the other topics in other lessons.